Our next speaker is Jonathan Lim. Jonathan is an Australian lawyer, geopolitical analyst, and project co-lead of the Jus Ad Astra Project, a legal project focused on the analysis, development, and adoption of human rights values and principles across outer space for the benefit of humanity. The project seeks the development of an authoritative international treatise clarifying the fundamental legal principles and human rights applicable to current and future human activities across the final frontier. John holds a Juris Doctor and Bachelor of Arts from Monash University and currently works as a solicitor at Wise Law, a specialist cyber law firm based in Melbourne, Australia. Jonathan, welcome to the Lunar Development Conference.
Hello, my name is Jonathan Lim. I am the project co-lead to the Jus Ad Astra Project. Today, as part of the 2020 Lunar Conference, I will be presenting my views regarding the need for human rights values and principles in creating a philosophical, moral, and legal basis for the support and advancement of human activities across the final frontier, encompassing humanity's anticipated presence on the moon and other celestial bodies in the near future. So just to provide a bit of information concerning our background, the Jus Ad Astra project was started in January 2020 as a project under Wise Law, a specialist cyber law firm in Melbourne, Australia. The other project co-lead, EJ Wise, acts as my supervisor at Wise Law, and EJ's 2 decades of experience as a lawyer within the Australian Air Force has helped to shape the objectives and identity of this project. The project has 6 volunteer research directors, each responsible for exploring the role which human rights plays across outer space within their defined research areas. This includes 1, economic, social, and cultural law, 2, environmental law, 3, the law of war, 4, the rule of law, 5, property law, and 6, health law. We have recently issued several documents regarding the need for a right to peace and moderating international conflicts in space, the issue of disability rights in space, and the need for the consideration of gender-neutral language across international human rights instruments in creating a common human identity. As outlined, the project's objective is set upon promoting broad discussion and analysis concerning the relationship between human rights values and principles and outer space. Through this, it is our aim to clarify how the application of existing terrestrial human rights frameworks holds many benefits for a future human spacefaring civilization by enabling states and communities to respect, protect, and fulfill their human rights obligations across outer space. So the impetus for starting this project was premised upon the distinct lack of discourse and dialogue concerning the relevance and role of human rights across outer space. While there have admittedly been debates surrounding the social concerns, legal and policy issues, space heritage, and the humanities in governing human activities in outer space, human rights offers a foundational perspective upon which all of these issues can be realized and addressed. So to provide a bit of context, my desire to explore the intersection of human rights and outer space arose from my personal interest in science fiction shows and movies, including Stargate, The Martian, and The Expanse. Likewise, noting the various influences of artists and authors, the role of science fiction serves to inspire innovation in the real world for those looking to the future of humanity. However, across science fiction media, the notion of law and order often appears as a secondary consideration to the technological elements, political intrigue, drama, and plot development. It is therefore provided that considering the presence of law and human rights within science fiction can be seen as a means of resolving conflict, addressing moral dilemmas, and balancing our perspectives on different cultures. So one key example herein concerns the opening episode of The Expanse, where you have UN Deputy Under-Secretary Christian Avasarala, who sought to extract information from a belter using gravity torture. We're simply subjecting the individual's microgravity-adjusted physiology to the Earth's natural gravity was sufficient to cause superfluous injury or unnecessary suffering. So the question thus arises, whether this constitutes torture, and whether that person's human rights were being violated. Additionally, consider the following several hypothetical examples. Firstly, you have a space laborer who is working on a colony stationed on the moon, mining resources under the employment of a private space company. However, the laborer's presence on the moon has come at a great financial cost to that company, which worked to transport them there. And the laborer's constant need to access basic elements critical to survival, such as water and oxygen, is paid out of any wages earned. So what happens when that person loses their job, or when the costs of these essential elements rises up beyond their means? Secondly, you have, say, a couple living on a space station who are looking to conceive and birth a child. However, the microgravity environment and effects of cosmic radiation present an inherent and significant concern regarding their ability to conceive and carry the fetus to full term. What precautions can be taken to minimize this risk? Do these precautions represent best practice? And how can such precautions be uniformly applied across to other peoples? Finally, a child growing up on a colony on the moon faces lifelong health risks associated with the reduced degree of gravity upon their skeletal and muscular system, while the impact of radiation has also given rise to a weakened immune system. So how will this child access to healthcare be managed? Should this child ever visit Earth, would they be able to survive the differing environmental conditions? So space is hard, and given the unique technical, physiological, and policy challenges associated with outer space, herein, exploring this intersection between human rights and space thus presents a new opportunity to ensure that all human beings continue to be treated with dignity, equality, and respect, and to recognize how the technology and environment of outer space will inhibit or support humanity's presence among the stars. So human rights are rights inherent to all human beings, whatever our nationality, place of interest, sex, national or ethnic origin, color, religion, language, or any other status. We are all equally entitled to our human rights without discrimination. These rights are interrelated, interdependent, and indivisible. Moving down this list, the notion of human rights is outlined by 6 key principles. Firstly, the universality of such rights. All people everywhere in the world are entitled to them. Speaking to our common humanity, these rights draw their principles and values from many diverse traditions and are made robust through a uniform codification at law. Secondly, all human rights are indivisible, whether they are civil and political rights, such as the right to life, equality before the law, and the right to health. So these rights are interdependent and interrelated, where the deprivation of one right adversely affects the others, and it is not possible to simply follow some human rights principles and disregard others. Third, human rights are interdependent and interrelated. Each one contributes to the realization of a person's human dignity through the satisfaction of their developmental, physical, physiological, and spiritual needs. So the fulfillment of one right often depends wholly or in part upon the fulfillment of others. Fourth, all persons and institutions, including the state, are accountable to just, fair, and equitable laws. Individuals are entitled without any discrimination to the equal protection of the law, the equal enjoyment of the rights. These rights promotes inclusivity, creates a framework for enforcement, and advances the overall objective and effective implementation of such rights. Fifth, all people have the right to participate in and access information relating to the decision-making processes that affect their lives and well-being. And finally, states and other duty bearers are responsible for the observance of human rights. States must comply with the legal norms and standards enshrined across the international human rights instruments to which they have agreed. Herein, upholding the rule of law forms a central value in ensuring fairness and justice. So in summary, the inherent, inalienable, and universal nature of human rights enables the establishment of a new governance framework on the moon and in outer space, one directed at safeguarding the fundamental dignity and value of every human being, promoting tolerance, equality, and respect as a means of addressing conflict across diverse and isolated human communities. Accordingly, the benefits of human rights can be viewed through the following aspects. Firstly, human rights ensures that every person's need to access oxygen, food, water, shelter, and healthcare is met. This ensures a baseline level of dignity and existence conducive to prosperity and social harmony. Secondly, human rights protect vulnerable groups, including racial minorities, religious minorities, and disabled persons. This takes the form of discouraging negative discrimination against them, obviously, but also positive discrimination, which ensures that everyone is enabled to enjoy a basic standard of human dignity conducive to the full realization of associated human rights. Third, human rights are seen as a guarantor of fundamental freedoms and civil rights, and the protection of freedom of speech and expression facilitates the creation of a free and open society. Indeed, such protections encourages public debate, promotes freedom of thought, and is conducive to a stable and prosperous society. Fourth, human rights protect the environment by encouraging sustainable practices and environmental responsibility. Finally, human rights provide a universal standard for holding governments accountable both to each other and to their citizens. So by highlighting the context and background of human rights in the domain of outer space, attention may be turned to several key events which took place during the Cold War. Herein, the events surrounding the space race and the national space programs of the US and Soviet Union provide potential insights into the elementary consideration of human rights values across outer space affairs. Firstly, we have the 1967 Soyuz 1 mission, where cosmonaut Vladimir Komarov was tasked by officials to participate in the first mid-space rendezvous between two Soviet spaceships, celebrating the 50th anniversary of the Communist Revolution. While Komarov expressed serious reservations over the 203 structural problems discovered with his space vehicle, the issue of national pride took precedent in forcing the mission to proceed. Consequently, Komarov would perish when the descent module of his spacecraft crashed into the ground upon re-entry due to a parachute failure. The question thus arises, was Komarov's right to life violated by Soviet authorities? Secondly, in 1975, both the US and Soviet Union agreed to a joint mission involving the mid-space rendezvous between a US and Soviet vehicle. The mission required active collaboration in accounting for the atmospheric and pressure differences between the two vehicles through the creation of a docking module. So where the success of the mission presented an immense technical achievement and contributed to a detente between the two powers at the time, it is also advanced that both sides realized and accounted for the right to life in tackling environmental control and life support concerns within the mission. Finally, the 1986 Space Shuttle Challenger disaster, where it was discovered that NASA's management ignored the recommendations of its engineers regarding the effects which below freezing temperatures might have upon the integrity of the solid rocket's O-rings prior to the launch. Upon launch, 7 people died when the vehicle exploded. And the question again arises, was the life of these 7 people violated by NASA? In summary, the presence of human rights is something which has been existent since the beginnings of human spaceflight. These examples demonstrate the associated dangers involved when states place the need for national pride and national interest over the interests and rights of states, while also demonstrating the beginnings of how states can cooperate to address the policy and technical challenges associated with fulfilling basic human rights associated with environmental control and life support systems. So the intersection between human rights and outer space can be viewed through two perspectives. Firstly, the use of outer space applications to support and further the enforcement and realization of human rights terrestrially. This has been illustrated through the use of Earth observation technologies to help decision makers understand trends, evaluate needs, and create sustainable development practices in the collective interest. Now, indeed, satellites have been used in the monitoring of human rights violations concerning ethnic cleansing of Rohingya populations in Burma, to track air quality measurements over Indonesia, and to assist in agriculture and sustainable development practices in Kenya, and also combating bushfires in Australia. Second, the extension of terrestrial human rights into the domain of outer space affairs. So it is this intersection of human rights and space law which proves most relevant to our concerns regarding potential human colonies on the lunar and Martian surface. This comes from the acknowledgement that where the technological advancement has all too often taken priority over the development of the law, the reckless advancement of humanity into space over the need for law and basic human rights poses an acute risk to the value and presence of human life on the moon and throughout outer space. While the commercialization of space represents significant opportunities to expedite the democratization of access to outer space, it also presents unique ethical and moral challenges to humanity's prolonged habitation on the lunar surface. The prioritization of commercial interests over fundamental human rights and dignity in the control, extraction, and use of natural resources integral to the survival and prosperity of human settlements on the moon will impede the full realization of human health and well-being, with significant implications for the survival and stability of human civilization in outer space. Firstly, concerning space mining, the destructive nature and hyper-capitalism tied to mining activities can give rise to noted impacts upon both the environment and human society. This can already be seen on Earth in how the use of mercury and certain chemicals within the mining process and the need for deforestation can cause unparalleled harm to the environment and leave an area uninhabitable. Human rights promote the exercise of the precautionary principle here and promote the preservation of outer space environment as the new international commons. And associated with this, where space mining activities are predicted to give rise to the world's first trillionaire, this immense amount of wealth will also give rise to socioeconomic concerns. Indeed, proposals from Elon Musk in 2018 saw him toy with the idea of humans living on a Mars settlement, working off their loans accrued during their move from Mars to Earth under an indentured servitude agreement, which shows great cause for concern. This notion demonstrated the terrifying inclination towards hyper-capitalism in outer space and a disregard of international labor achievements over the past century. Further, the general issue of inequality will also arise both between developed and developing space powers and within isolated human communities across outer space. Secondly, concerning space tourism and the moon, attention may be turned towards SpaceX's ambitions to send the first private passenger on a flight around the moon, Japanese billionaire Yusaku Maezawa, by 2023. However, what happens when an accident like Apollo 13 arises? How can a state fulfill the individual's right to life under this circumstance? This raises concerns over the possibility of mounting a rescue effort, both from a technical view and from a legal perspective. Article 5 of the Outer Space Treaty defines astronauts as envoys of mankind, whom are therefore subject to the protections afforded under the 1968 Rescue Agreement. However, the tourist in this case would not qualify for this classification and would likely be seen as a human spaceflight participant, which is a term commonly used by international partners within the International Space Station. Further, the question of liability would arise where the victims to decide to pursue subsequent legal action against the private company under the tort of negligence. Where launch states remain absolutely liable under international space law agreements, this raises questions over how such claims can be enforced against the specific launch company. Finally, in the context of the human colonization on the moon and across space, it is presented that the presence of human rights is conducive to ensuring the success and prosperity of human colonies. So reference may be had to the 2014 Extraterrestrial Liberty Conference, where participants there considered the possibility of a Bill of Rights for Mars. Accordingly, relevant human rights values and principles in this context include the right to health concerning giving birth in space, to which protections for the rights of the child may also be considered, cultural rights in relation to the preservation of space heritage sites and artifacts, the right to work and free choice of employment concerning labor issues, and the right to a fair trial and due process in relation to criminal justice matters. So in the aftermath of the Second World War, the international community, apprehensive to the horrors of the Holocaust and the occurrence of two world conflicts within the span of 30 years, collectively decided to promote and encourage respect for human rights through international cooperation. Under the contemporary international human rights law framework, universal human rights have often been expressed and guaranteed by law in the forms of treaties, customary international law, general principles, and other sources of international law. As listed, the framework is comprised of the International Bill of Rights and subsequent human rights agreements. In applying these agreements extraterritorially, that is beyond the borders of a state and into the domain of outer space, reference may be had to, firstly, the International Court of Justice's 1970 Namibia advisory opinion, where the court held that the title of a state over a particular territory is not a prerequisite for the extraterritorial application of human rights law, but that the state's physical control over said territory is sufficient. Secondly, the 2011 Maastricht Principles on Extraterritorial Obligation of States, which provided the obligation for states to extend the observation and realization of international human rights law values and principles extraterritorially. The document promoted the concept of extraterritorial obligations as a means of addressing the missing link in the universal human rights protection system, one which allows human rights to assume their proper role as a legal basis for regulating globalization and ensuring universal protection. It is also evident that the contents of the various listed international space law agreements provide opportunities for the application of international human rights law into international space law. In considering these agreements, one must direct their attention to the geopolitical character of the space race and the Cold War. During this period, there were no private space companies. There was active competition rather than collaboration between the US and USSR for the majority of the period. And the domain was dominated by two superpowers and national space agencies. Consequently, bringing the domain of international human rights law into international space law requires a consideration of the following provisions. Firstly, Article 3 of the Outer Space Treaty specifies that activities conducted by states parties must be carried out in accordance with international law, including the UN Charter. Article 2 of the Moon Agreement also specifies that all activities on the Moon, including its exploration, use, shall be carried out in accordance with international law, in particular the Charter of the United Nations. Now, the means by which these articles may be interpreted can be determined by reference to Article 31(1) of the 1969 Vienna Convention, which outlines that a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. Accordingly, the space law articles here may be read as stating that in whatever space activity a state undertakes, such an activity must be in accordance with the international law which is relevant and applicable. This follows that states parties to these agreements bear the onus to rationally establish the basis by which the relevant dimensions of international law, i.e. international human rights law, applies into international space law under the agreements. The relevant body which oversees the application of these space law agreements is the UN Office for Outer Space Affairs, which also serves as the Secretariat for the General Assembly's only committee dealing exclusively with international cooperation in the peaceful uses of outer space, the United Nations Committee on the Peaceful Uses of Outer Space. So UNOOSA has acknowledged by implication the association between human rights and outer space affairs through the objectives of the 2030 Agenda for Sustainable Development, providing the opportunity for governments and the international community to renew their commitment to improving the health and well-being of their citizens under the UN Sustainable Development Goals. In supporting the realization of the Sustainable Development Goals, UNOOSA has sought to explore how outer space can be utilized to support sustainability, development, and human rights principles on Earth. It is evident that space-based services and technologies are key in understanding climate change, managing the full disaster management cycle, promoting life on land and below the water, and so forth. Accordingly, it is advanced that the application of human rights into space can serve as the basis for a new social contract between states and individuals in the following respects. Firstly, the right to own property is recognized under Article 17 of the Universal Declaration of Human Rights. Regional human rights bodies also recognize this right with Article 1 of Protocol 1 to the European Convention on Human Rights, outlining that it is the right of natural and legal persons to the peaceful enjoyment of his possessions, of course subject to the general interest or to secure the payment of taxes. Secondly, maintaining the rule of law is relevant to issues of equality and non-discrimination, criminal justice, and fairness. Third, supporting the transference of values and ethical practices relates to the preservation of cultural identity, including aspects of nationality, religion, and language. Fourth, safeguarding human dignity is relevant in ensuring the provision of resources and services considered essential to human dignity and existence. Fifth, reinforcing a common human connection with terrestrial governments ensures similarity of views and principles between Earth and isolated human communities, promoting good governance and the maintenance of human links, person-to-person links. Sixth, promoting sustainable practices and environmental responsibility in precluding and managing the challenges of, say, space debris. And finally, the holding of governments accountable helps to prevent abuses and provides recourse for countering injustices. So to meet the unique challenges associated with humanity's prolonged presence and activities across the expanse of space, there arises the need to advance the development and adoption of new human rights values and principles. The most apparent means by which human rights come into existence as norms of national and international law are created by enactment, custom, and judicial decisions. At the international level, human rights norms exist because of treaties which have turned them into international law. However, the basis of human rights can be seen as founded in the idea that such principles and rights possess roots that are deeper and less subject to human decisions than legal enactment. This includes their founding as attributed to, say, divine degree, as part of actual human moralities, or as justified ethical outlooks. In considering the circumstances of human habitation on the moon and in outer space, the resulting moral rights which arise feed into the need for the following three core rights listed. The advancement of these three rights under the Jus Ad Astra Project are premised on the moral considerations of equality, autonomy, human dignity, fundamental human interests, the capacity for rational agency, and democracy. Concerning the right to water, this right was recognized by the UN General Assembly on 20th of July 2010 through Resolution 64/292. Now, this resolution specifically recognized the human right to water and sanitation, acknowledging that clean drinking water and sanitation are essential to the realization of human rights. The UN called upon states and international organizations to provide financial resources, help capacity building, and technology transfer to help countries, in particular developing countries, to provide safe, clean, accessible, and affordable drinking water and sanitation for all. Within the context of human activities on the moon and across outer space, the application of this right must account for the financial costs involved in transporting, recycling, and mining for water within a lunar colony. Where the existence of water within deep craters on the moon has been speculated. Its extraction will obviously come at a cost. Further, where the multiple uses of water beyond human consumption must be considered, including for the creation of rocket fuels or for breathable gases such as oxygen as well. And on the lunar surface, the recognition of access to water and sanitation as enforceable human rights would reflect the fundamental nature of this basic element within the lives of each person. Conversely, the lack of access to safe, sufficient, and affordable water, sanitation, and hygiene facilities has a devastating effect on the health, dignity, and prosperity of individuals residing across outer space. In relation to the right to a breathable atmosphere, the right to breathe clean air is considered as a developing component of the right to a healthy environment within international law. This has been associated with the responsibility of governments to regulate human activities which have a pollutive impact upon the air, ranging from the use of certain cooking fuels within homes across developing countries to managing large-scale polluted air caused by factories or industrial means, as observed across China and India. In 2019, the UN Special Rapporteur issued a report concerning human rights and the environment, which called upon countries to fulfill their human rights obligations by taking urgent action to improve air quality. So within the context of human activities on the moon and across outer space, the need for a right to a breathable atmosphere is faced as such, given the acknowledgement that oxygen may not prove the best gas for long-term human habitation. This is given the associated health risks such as oxygen toxicity and safety concerns such as the potential for fires to occur within a pure oxygen environment. Further, the right to a breathable atmosphere draws the need to consider the composition of the breathable atmosphere to be provided, following upon the concept of breathable gas in scuba diving, where the use of nitrox, heliox, and trimix have been used as alternative gases for scuba diving. Additionally, the right to a breathable atmosphere elicits the need to consider the pressure of the breathable atmosphere within the enclosed habitat or space vehicle. This has a tied effect upon the size and design of the vehicle and habitat, along with the containers used to hold these gases. Finally, the right to a breathable atmosphere requires the consideration of the issue of hygiene. This is given the history of the Russian Mir space station between 1986 to 2001, where cosmonauts who lived aboard the station's confined, dirty, and sweaty conditions had an estimated 50,000 microorganisms per minute, compared to terrestrial conditions, where the average person sheds 3,000 per minute. Herein, the failure to maintain proper hygiene conditions resulted in skin disease, respiratory infection, and food poisoning amongst the station's crew. Finally, in relation to the right to a habitable environment, the right to a healthy environment is considered as customary international law, requiring states to adopt measures to ensure a safe, clean, and healthy environment. This is comprised of a number of A, substantive rights, including the right to health, life, water, and procedural rights, the right to access information, access to justice, public participation, so forth. So the right to a healthy environment is recognized as a legally enforceable right across 181 countries, which have become bounded to this right as a result of treaties, inclusion within their national constitutions, and legislative instruments to which they have agreed. Within the context of human activities on the moon and across outer space, the need for a right to a habitable environment is phrased as such, given the inherently hazardous conditions and environment of outer space, and the acknowledgement that states may never be able to adequately meet the comparable levels of obligations to satisfy what is considered healthy in terrestrial terms. There thus exist three elements to the fulfillment of the right to a habitable environment. Firstly, the obvious need for shelter, where human beings would expire pretty quickly within the vacuum of space. Secondly, the need for an acceptable degree of protection from cosmic radiation, given the noted effects of radiation upon human physiology, which can give rise to an increased incidence of cancer. Third, the need for the provision of an acceptable standard of gravity, given the adverse effects which too little or too much gravity can have upon the musculoskeletal and cardiovascular systems of human beings. In the enforcement of these novel rights, the means by which state obligations have been enforced in relation to social, economic, and cultural rights specifically adheres to the idea of a tripartite topology, conceptualized in 1980 by Henry Shui. The topology outlines how states bear several obligations in relation to human rights. Firstly, the negative obligation to avoid depriving or interfering with the enjoyment of rights. Second, the positive obligation to prevent others from interfering with rights or depriving others from the enjoyment of such rights. And finally, the positive obligation to aid the deprived by adopting appropriate measures towards the full realization of such rights. States thus bear the respective obligation of respect, protect, and fulfill in relation to their human rights obligations. Furthermore, outlining the practicality of the right to a breathable atmosphere and the three core rights as human rights values and principles fundamental to be applied into the domain of outer space requires consideration of an additional typology of traits typically used in the advancement of individual human rights. Ongoing efforts within the international community to clarify the normative content of social rights under international human rights law has involved the identification of key characteristics that the goods or services that individuals have a right to should present. Establishing this clarifies the content of the duty of the state to provide such goods and services considered essential to the enjoyment of all human rights. So human rights commentators have developed a list of the conditions that the delivery of corresponding social goods or services should comply with, which has been highlighted by former Special Rapporteur on the right to education, Katerina Tomaskeri, under the topology of 5 A's as listed. Firstly, we have availability, that enough of a good or service must be available in relation to the needs of an individual. Secondly, accessibility, that the good or service should be accessible to all without discrimination. Third, adequacy, that the good or service must present certain essential qualities. Fourth, acceptability, that the good or service provided must take into account cultural and religious norms in the ways in which it is provided. And finally, adaptability, that the good or service provided should be regularly evaluated and improved in the light of the feedback from the beneficiaries in the progress of science or of changing social norms. So in conclusion, where human rights can be considered in all circumstances and applied extraterritorially, The international human rights framework provides the ideal mechanism through which we can realize and enforce human rights on the moon and throughout outer space. The current international human rights law framework is premised upon 9 core international agreements which are maintained and enforced under the authority of dedicated UN bodies and special rapporteurs in cooperation with states parties. It is advanced that the existing international human rights system provides the most effective, coherent, and immediate means for managing the challenges associated with respecting, protecting, and fulfilling states' obligations pertaining to human activities across outer space by instilling respect and adherence to core rights and principles conducive to the long-term survival and prosperity of humanity. Moving forward, it falls upon the concerted efforts of governments, private companies, civil society organizations, and individuals to advance the cause of human rights in outer space to ensure good governance and the maintenance of international peace and stability. For the rights of every man are diminished when the rights of one man are threatened. So that marks the end of the presentation. Thank you for joining me today, and I hope you enjoy the rest of the conference.